Of its kind case about land rights in Iowa went to trial today. A carbon capture pipeline company asking a judge to compel landowners to allow a survey of their land without their consent.
The judge is considering arguments about whether the landowners and their tenant were given the proper notice through the mail. KTIV's Matt Hoffman was in court today, joins us in studio tonight, and with more, what impact could the judge's ruling have on this case, Matt?
Yeah, Matt, it's really the first full-fledged trial in the legal battle over carbon capture pipelines. Even though the pipelines are private, for-profit companies, the companies behind them, seek permission to use eminent domain to install those pipes. Two Woodbury County residents are at the heart of the case, sued by Heartland Greenway, one of the pipeline companies building their Navigator pipeline. The company alleges it has the right to survey Vicki and William Hulse's land without their permission. The company made its pitch to a judge today, saying the preliminary surveys are not invasive.
That is laid out in whatever statute based on the type of survey. If the statute says if you find this, then you must continue and do this. So we have to follow that protocol that's laid out for the requirements.
The Hulse family is fighting the pipeline company at the very first step, a series of surveys which include cultural and environmental factors. In fact, the Hulse family argues a civil survey was already conducted without their knowledge, but ultimately they object to the entire project, even if the pipeline company should prevail at trial.
Can come on my property any time of day against my will. Anytime that they want, they can survey my land against my knowledge.
For its part, Heartland Greenway says Iowa law explicitly allows these surveys. It presented evidence that several letters were sent to the Hulse family, including one the family declined to sign for. The company also argues it has already held dozens of informational landowner meetings, and that the vast majority of the surveys across the 5,000-plus parcel route have gone on without any incident.
It seems a lot of the testimony focused today on the MEL system. What was really the importance of that?
Yeah, Jessica, basically the company argues Iowa law only requires them to notify the landowners before conducting the surveys, not actually get their permission. So the company says they only have to prove the letters arrived, that the family was in fact aware.
And Matt, what about a decision from the judge? When could we get that?
Yeah, of course, the judge heard testimony all day, and he said he'd take the matter under advisement and issue a decision. Any post-trial briefs are due within the next 10 days, and the judge said he'd make a decision quickly thereafter.